Hello, everyone. Happy Tuesday to you all. We're back here with a great lineup again today of presenters. Before I go over today's lineup, I want to mention again that Bond will be hosting a breakfast briefing across 13 cities in New York State over the course of September and October. And the topic is managing the struggling employee, mental and emotional health, and the law, a topic that I know a lot of clients have been asking questions about. So we don't have a link here. I will try to put a link in the Q&A actually. I don't have a slide with the link today though. But do try to join us since we're in 13 places. Hopefully we're somewhere close to you. All right, moving on to today's agenda. We have first we have Katie McGraw, an associate in our Buffalo office, talking about some proposed legislation in the litigation realm. Subha Viswanathan's back with us with another wage and hour topic, which we always appreciate. Seth Gilbertson's here from Buffalo to talk about defending borrower defense claims, something related to the higher ed industry. And then I'll finish things off talking about temporary employee staffing agreements. So with that, I'll turn it right over to Katie.
Thanks, Kristen. Good afternoon, everybody. I just have a little update here on some proposed legislation in New York State that has the potential to impact what's called long arm jurisdiction for non-New York business entities. So this is Senate Bill S7476, proposed in 2023. It has passed the New York State Assembly and the New York State Senate, and it is, not yet, but will go to the governor to sign. It is an amendment to a couple different statutes, but the CPLR, which is New York Civil Practice Law and Rules, Business Corporation Law, the General Associations Law, the Limited Liability Company Law, the Not-for-Profit Corporation Law, and the Partnership Law. And essentially what it would do is amend each of those statutes, in the same way that would automatically confer what's called general jurisdiction on non-New York, so foreign registered entities that register to do business in New York State. So if you're not a New York domiciled entity and you want to do business in New York State, you have to register with New York State and nominate an agent to accept service of process. And, until, but not yet still, because this is proposed, but as recently as 2021, New York's highest court, the Court of Appeals, has said that the simple act of registering to do business in New York does not on its own confer general jurisdiction. So what that means is general jurisdiction means your ability to be sued in New York State courts for something that did not occur in New York. So, the current state of the law, if this law does not pass, is that you have to have sufficient contacts in New York State to be sued here. So typically that means the underlying claim has to have arisen here, or you have to have, do so much business in New York, like maintain an office, that it would be constitutional to, subject you to suit here. But this law, should it pass, would negate that and would automatically say that registering to do business in New York is consenting to be sued here. This is obviously a big change, and it is modeled off of a law that was recently passed in Pennsylvania. So Pennsylvania passed a very similar amendment to its statutes, and not surprisingly, that was challenged on constitutional grounds. It made its way up through the Pennsylvania court system, and ultimately the highest court in Pennsylvania had said that it was not constitutional. So it applied the long-standing, familiar United States Supreme Court tests of having sufficient contacts with the state. And the highest court of Pennsylvania said it would violate due process. It would not be constitutional to subject foreign entities, foreign corporations to jurisdiction in Pennsylvania if they don't have sufficient contacts here. That case was appealed to the United States Supreme Court, which in June of this year reversed the highest court of Pennsylvania and held that Pennsylvania statute was constitutional under the due process analysis. That was an interesting decision, and it, paved the way for Pennsylvania's law to go forward. Obviously now New York is a very similar statute, and were it to be subject to the same constitutional challenge, that Supreme Court case would control. With one caveat, I will say Justice Alito wrote a concurring opinion, concurring with the holding, but stating that he thinks that Pennsylvania's law is potentially subject to challenge on Commerce Clause grounds, but that issue was not preserved for appeal. So it was not properly before the Supreme Court. So, interesting potential constitutional challenge, although as of now, Pennsylvania's law is constitutional and, being enforced. And, what that would mean in New York, should Governor Hochul sign the bill, is foreign registered entities. So if you're a foreign corporation, non-New York corporation, LLC, partnership, you could be subjected to litigation in New York that you may not have, previously contemplated. So you could be sued conceivably under this law for a car accident that didn't take place in New York, or, business dispute that had nothing to do with New York. And that's problematic for a couple of reasons. A lot of people have criticized, raised concerns about this bill on, is it going to overburden the New York State court system? What's going to happen? Is it just going to be form selection? Are people just going to start suing entities that really have nothing to do with New York in New York because it's favorable? And, a lot of those are legitimate concerns, and the bill's sponsor have kind of, written it in the, legislative intent here to kind of ward off some of those. But they've said, there's still what's called the doctrine of forum nonconveniens, and New York courts retain discretion to dismiss cases that shouldn't be brought in New York, where there's really not sufficient grounds to do so, or where venue's inappropriate or whatever. And, I think the bill sponsors are saying that would still be equally as enforceable, and New York courts will be able to control their dockets in that way. But, there are legitimate concerns, and, rightfully so. I think foreign registered entities and New York courts are concerned about this. So still proposed, not yet to be passed, unsure whether Governor Hochul will sign it or not, and then exactly how it will shake out in terms of, whether courts start enforcing, applying the doctrine of forum nonconveniens and kicking these cases out because they shouldn't have been sued here. So just an interesting, proposed legislation. Stay tuned for more to come on it and how it may roll out if it's passed.
Thanks for that. Interesting discussion of the constitutionality of it, because as I was listening to the first part of your presentation, I was sort of transported back to the law school thinking this can't be constitutional. And you answered the question.
The Supreme Court applied the international shoe test and the worldwide, Volkswagen test. So
it takes me back. And sort of the bonus lesson of this presentation is, if you have offices in Pennsylvania, right, you could be sued in Pennsylvania, it sounds like.
Yes.
All right. Really helpful. Thank you so much.
Thank you.
Enjoy the rest of your day. We're going to move on next to Subha Viswanathan, who's a member here in our Syracuse office, to talk about meal period requirements, which I've been discussing at home this week. My kids have a summer job this week at the New York State Fair, and they haven't been getting their meals. And I'm saying, it's the law. New York State should know that you should be getting your meal periods. So tell us about it, Subha.
Who knows if the DOL will enforce that against the New York State Fair or not. I'm just going to talk about the meal period requirements. It's important from time to time to review these requirements, as well as really all wage and hour requirements, just to make sure that your policies and practices are compliant and haven't gotten lax in terms of making sure that they're being followed. And also with remote work becoming more and more common after the pandemic, it's important not to lose sight of the fact that these meal period requirements apply just as much to your remote employees as they do to your in-person employees. And you still need to make sure that your remote employees are not only taking their meal periods, but also that you are documenting the fact that they're taking their meal periods. So let's just kind of start with the statutory requirements. Next slide, please, Kathy. So the meal period obligation applies to all shifts of more than 6 hours. So technically, if there's a shift of exactly 6 hours, let's say 9 a.m. to 3 p.m., you're technically not required to provide a meal period for that shift. Most employers do, and I think it's a good idea to apply the meal period requirements to shifts that are scheduled for exactly 6 hours, because you can't always control if an employee punches out a couple of minutes late. So if the employee punches out at 3:02 and that shift then becomes a shift of 6 hours and 2 minutes, you're technically not in compliance at that point if you didn't provide a meal period during that shift. So general rule of thumb is any shifts of 6 hours or more, make sure that you're providing a meal period. The meal period requirement for the noonday meal period, which applies to any shifts that extend over 11 a.m. to 2 p.m., differs based on the type of employee. So factory employees, under the statute at least, are required to get a 60-minute meal period between the hours of 11 a.m. and 2 p.m. Employees of other establishments are required to get at least a 30-minute meal period between the hours of 11 a.m. and 2 p.m. As we'll talk about in a second, the Commissioner of Labor has shortened that without a variance. So most employers just stick with a 30-minute meal period that the Commissioner has approved. For shifts starting between 1 p.m. and 6 a.m., the requirement is to provide the meal period midway between the beginning and the end of the shift. There is a requirement under the statute to provide a second meal period. So any shifts that start before 11 a.m. and end later than 7 p.m. have to include a second meal period of at least 20 minutes between the hours of 5 p.m. and 7 p.m. And the statute does give the Commissioner of Labor discretion to permit shorter meal periods than the meal periods that are required by statute. Next slide, please, Kathy. As I mentioned earlier, the Commissioner of Labor's guidelines state that 30-minute meal periods are permitted for all employees without applying for a variance. So despite the statutory language of 60 minutes for factory employees, you can provide a 30-minute unpaid meal period for all employees. One other thing that the Department of Labor guidelines state is that their enforcement position is that the meal period requirements apply to all employees, including employees that are exempt from overtime requirements. So white-collar employees that fall within the administrative, executive, professional exemptions. The Department of Labor's official enforcement position is that those employees are also required to get a 30-minute uninterrupted meal period. That being said, I've never seen an audit that included that issue being investigated, and I've never seen an enforcement action with respect to white-collar exempt employees not receiving meal periods. And even if there was, there likely wouldn't be any monetary liability associated with it, because obviously the white-collar exempt employees' salary would cover all hours worked, regardless of how many hours they work. There is an exception in the guidelines for one employee shifts or situations where there's only one employee in the particular occupation, and that occupation is so vital that the person can't be relieved from duty when taking the meal period. Under those circumstances, the employer can get written consent to the employee essentially eating during their shift, eating while on the job. You should get written consent to it, and those meal periods have to be paid. So if you do have a one employee shift or one employee occupation, then you do have to pay for that meal period if you're requiring the person to work while eating. Employee waivers of meal period requirements can be allowed under limited circumstances. There's a Court of Appeals case, the highest court in New York, issued a decision stating that under a collective bargaining agreement, where employees waive the requirements for the meal period under the statute, but receive other forms of breaks and receive other negotiated benefits in exchange for waiving the meal periods, then the meal period requirements can be waived under those circumstances. So the Department of Labor's enforcement position is that under those very limited circumstances, where the employer can show that there are operational needs that make it impossible or impractical to provide everyone with a 30-minute uninterrupted meal period, and the waiver is obtained openly and knowingly without any evidence of coercion or duress, and the employees receive a desired benefit in exchange for the waiver, the Department of Labor will enforce the waiver. The Department of Labor has said, though, that leaving early, so leaving 30 minutes early at the end of a shift, is not a sufficient benefit for waiving the meal period. So that's not going to pass muster. If you have, for instance, an 8:30 to 5 p.m. shift, and instead of giving the person a 30-minute meal period between 11 a.m. and 2 p.m. as required by statute, the employee says, I just want to leave at 4:30 and I'll just work straight from 8:30 to 4:30. That waiver is not going to be enforced by the Department of Labor. Employers cannot require meal periods to be taken at the employee's desk or workstation because the Department of Labor will presume that they're not sufficiently relieved from duty if they're being required to take their meal periods at their workstation. But there's nothing wrong with requiring employees to remain on work premises. Next slide, please, Kathy. So the general rule of thumb is that if an employee files a complaint with the Department of Labor or a court stating that they did not receive their meal periods as required by statute, their version of events is going to be accepted as true unless the employer has records to demonstrate that the employee actually received their meal periods. So the best evidence is clocking out or clocking in. So if you have contemporaneous daily records that show somebody clocking out for their meal period, the exact time that they clocked out and the exact time that they clocked back in, that's going to be the best evidence to demonstrate the person actually received a meal period. I know that it's kind of outdated for employers to have an actual time clock where people take a card and punch a clock. But other forms of electronic timekeeping are equally good. There's timekeeping apps on cell phones. There's computer systems. Those types of electronic records are going to be just as good in terms of showing start and end times of meal periods. Especially for remote employees, those are the kinds of systems that can be used to track meal periods for employees that are working on a remote basis. Even sending an email to the supervisor saying, I'm starting my meal period, and then sending another email to the supervisor at the end of the meal period saying my meal period is over. And maintaining those records in the individual's payroll file. That's going to be just as good as well. Written acknowledgments on timesheets can be okay. They're not quite as good as having the contemporaneous daily records that show the time out and time back in. But if you just require employees to keep timesheets on a daily basis where a person says, I started at 8:30 a.m., ended at 5 p.m., and you have an acknowledgement on the timesheet that says, I took a 30-minute unpaid meal period between the hours of 11 a.m. and 2 p.m., and the employee signs it on either a daily or a weekly basis, that will likely be okay. That will likely pass Department of Labor's approval. One system that is generally disfavored, I can't tell you that it's absolutely contrary to law because it's, there's nothing explicitly unlawful about it, but it's disfavored to have automatic meal period deductions without some sort of contemporaneous record that shows that the person actually took meal periods. If you have a system that it's impossible or impractical to actually get people to clock out and clock in or sign out and sign in on a daily basis for their meal periods, and your only recourse is to just deduct the 30-minute meal periods, here's what I would recommend. Have a written policy in your handbook that says meal periods will be deducted. Everyone is required to take a 30-minute meal period on an unpaid basis. Train employees regarding the requirements to take a meal period. Train your supervisors regarding what the procedure is for getting a report of someone who had to work through a meal period, and explain to everybody what the procedure is for overriding the meal period deduction. Under those circumstances, maybe the Department of Labor will accept the automatic meal period deductions as a defense to a meal period claim. Again, though, I generally wouldn't recommend it unless it's really, really administratively difficult to try to keep the contemporaneous records of meal periods taken. Next slide, please, Kathy. So in terms of enforcement, there's a 6-year statute of limitations for these types of claims. So obviously, if somebody files a claim and it ends up being a class action, or the Department of Labor audits a wide group of employees who aren't receiving meal periods, or that you don't have evidence that they receive meal periods, the Department of Labor or court can go all the way back 6 years and take that half an hour that the people weren't paid per day and impose that as back pay liability for the entire 6-year period. The Department of Labor will also issue a compliance order. 100% liquidated damages of the amount of the back pay is virtually automatic in a Department of Labor administrative proceeding. If employees end up filing a class action or even an individual action in a court for failure to receive meal periods, the employee would be entitled to get their attorney's fees paid for. Interest is available on the back pay, and there could potentially also be civil penalties for repeat offenders or especially egregious offenders. So this is something that you should periodically review. Make sure your policies are up to date. Make sure everybody understands the obligations to take a meal period, and hopefully you can avoid liability for this. That's it for me, Kristen.
Okay, thank you so much for that refresher on meal period requirements. There are a few questions for you, not surprisingly. I think you answered some of them, but thanks so much, Suba. Next, we are going to turn it over to Seth Gilbertson out in Buffalo, who works with a lot of our higher ed clients, and talk about a new development in this area of borrower defense claims, which I don't know much about, so looking forward to learning about it. Thanks, Seth.
Thanks, Kristen. And for those of you who turned into our pop-up webinar on Friday, you can kind of tune out from this because it's going to be a brief summary of that webinar just for the greater audience here, or those who weren't able to make it. Next slide, please. So borrower defense is part of the Title IV federal student aid program. And so I just want to give some background here on where we are with the student loan sort of landscape. There are a few points I want to make here. First of all, you hear about the student loan crisis quite a bit. It is real. The figures are somewhat staggering. And there are a lot of individuals that are having a lot of difficulty repaying a high number student loan that are really just coming back due after a long period where payments were not required during and after the pandemic. This has been a central priority of the Biden administration. I think both an educational priority and a fiscal budgetary priority. And they have been very aggressive. The Biden administration has been very aggressive in pursuing remedies or potential remedies for the student loan problem. You probably have heard of some of those. One is a massive forgiveness program that was struck down by the Supreme Court. There are other programs, though, that are moving forward pursuant to the administration's priorities, rulemaking, policy decisions, etc. And one of those is borrower defense. Now, there's litigation in this area, too, that I'm going to talk about in a moment. And then finally, a lot of this comes at a time of historic low confidence levels in higher education among the American public. And the reason I mention that is that it creates both a political incentive for the Biden administration, other public policymakers to be tough on higher education institutions, and it creates sort of a PR vacuum, a PR. It makes the PR battle that much more difficult for higher education to fight when there are adverse decisions against actions of higher education institutions. Next slide, please. So what is borrower defense? Borrower defense is really just what we call sort of the federal regulatory scheme that's built around this notion that if there is fraud or misrepresentation involved in the incentive to get somebody to come to a college or a university or even a trade program, and they receive a loan for that program, and then they don't get what they thought they were supposed to get or what they were told they were going to get. They're told they were going to get a Mercedes-Benz and they got a Kia. Therefore, they shouldn't have to pay the loan on the Mercedes. That's kind of the idea here is I was told I was going to get all these great things and have all these great job offers when I graduated. And it turned out I had, not the same education that I was promised and not the same subsequent job opportunities that I thought I would have. Therefore, I shouldn't have to repay my loans. The Department of Education will look at these applications and determine whether or not they are valid, whether or not there was indeed fraud or misrepresentation. If they determine that there was, and we'll talk about some of the standards that apply in just a minute, then they may relieve those loans and even refund the amounts that had been paid on those loans thus far. Then there's a second part of the process whereby the Department of Education may go to the educational institution, the college or university that was sort of found responsible for the fraud or misrepresentation, and then try to recoup those funds, which can be enormous amounts of money in some of these cases. You've seen some in the billions of dollars range particularly against for-profit institutions. Those tend to be the main target, but not exclusively. So borrower defense has been around for a while, but it's tended to be sort of a smaller number of claims against a smaller number of institutions, not something that's affected sort of the mainstream private or public nonprofit higher education sector. That may be changing. Next slide, please. So we have a few current developments. The first one, and some people may have heard of this case and not paid much attention to it because it really involved a number of plaintiffs against primarily for-profit educational institutions, but really the class of individuals that was represented by the plaintiffs in this case is much larger. As many as 300,000 potential borrowers brought claims saying basically under the Trump administration, these borrower defense applications were just being ignored. They were just sitting there languishing, and the administration hadn't done anything about them, and they had just been building up over a number of years. The Department of Education really did very little to try to defend this lawsuit because I think they had all these claims they hadn't done anything with. They needed to resolve that in some way. The regulations say that they are going to accept these applications and evaluate them, and they apparently weren't doing that. So part of the settlement that they put in place was a promise to everybody who had an outstanding borrower defense application in November of 2022 that they would process that within a certain period of time, depending on when it was, or based upon when it had been filed. And that's kind of where we are now. The Department of Education is scrambling to evaluate hundreds of thousands of claims in a very short period of time. Very short, relatively speaking. It can be anywhere from the next 3-6 months to 3 years. But there are a number of those that are sort of becoming due. And so we're seeing a lot of those flow into institutions, and I'll talk about the process for doing that in just a minute. In addition to that, as part of its public policy agenda that I talked about before, the Biden administration also implemented new regulations on July 1st that were intended to pave the way and make applying and receiving the benefits of borrower defense or having your loans relieved easier. And that was clearly the goal of these regulations. Immediately, a group of for-profit institutions sued the Department of Education. They currently have an injunction in place nationwide, put in place by the Fifth Circuit Court of Appeals. in Texas, known to be one of the more conservative circuits. And that's going to come up for hearing in November. So as of now, the July 1st, 2023 regulations are not active, but we'll see how effective that injunction is when we see how some of these claims are actually being evaluated, what standards the Department of Education is actually applying. It's going to be a little bit of a black box here, determining how current applications are being evaluated by the department that has already announced that it has these regulations. It's what it thinks should be the standard. So that's a lot of this activity has led to a recent flood of claims, as well as the backlog that the Department of Education is trying to get through. Next slide, please. So the claim evaluation process is it's kind of a labyrinth. It begins with a very simple online borrower application. Then the Department of Education sends that out to the institution. Sometimes it sends it out to the institution a few years later, as we're seeing now. Many of the applications we're receiving at client colleges and universities are several years old, which makes responding a little bit more difficult. But eventually, the Department of Education will seek a response from the institution. And then the Department of Education will issue a determination on those at some point in time. Again, there are timeframes set forth in the Sweet v. Cardona litigation settlement that's going to put some pressure on the department to actually decide these things. What standard they're going to use depends on a few things. Is it a claim that's covered by the settlement? Is it a claim that came in during prior regulations? Will it be a claim that's evaluated after the current or the 2023 evaluations are reinstated or revised in some way? Something is going to happen with those regulations. And when it does, that is going to affect how these applications are evaluated, as well as the timeline. The borrower can appeal that if they don't get the decision they want. The institution can challenge that in court if they don't get the decision they want. And then ultimately, the Department of Education can determine whether or not it wants to pursue a recoupment action, that is, get the funds back that were returned to the borrower from the institution. That does require a hearing for the institution, which is one of the reasons why we want to set ourselves up for success in that hearing if that were ever to happen against any of our client institutions. Next slide, please. So one of the best way at this point that an institution that has received some of these, and we know many have, there's recently been sort of a flood of these coming in from the Department of Education. And they are a bit misleading because when they send it out, they basically say, they being the Department of Education, basically says to the institution, you may respond. We really encourage you to respond and to respond aggressively because, again, the consequences for an adverse finding can be very large amounts of money. Even if they're just one or two claims, can be tens of thousands of dollars, if not even more than that. The Department of Education will not consider evidence that you don't give it. So you're much more likely to get an adverse decision. And under the 2023 regulation, they may even presume, the Department of Education may even presume that you don't contest the claim if you don't put in a response when they ask for it. So when they say you may respond, you should hear, I must respond. Next slide, please. What you would be doing right now. First thing you do is you collect documents. These are all the best steps. I highlighted the two most important ones. You want to make sure you have the documents that you need, the responses you need. You talk to anybody who was involved, borrowers' experience that they're complaining about. And we really think you should engage counsel here because you want to make sure that you're raising the right defenses that will ideally give you success at this first level, but if not, at the very least, give you success or the ability to challenge the department's findings and ultimately push back against any kind of recoupment action, which could be extraordinarily detrimental to the institution. Thank you.
Okay, thanks, Seth. Really interesting, even if you're not in higher ed, just to know that this is going on out there. Astounding amounts of money involved. So really, really interesting. Okay, so back to me now. I'm going to cover our final topic today, or for the next, I guess, 7 or so minutes. we always like to make this webinar a mix of new developments and sort of things that you, sort of housekeeping matters. I would say that my presentation falls into the same category as Suba in that regard. I'm guessing that, many of our clients out there do have arrangements with temporary employee staffing firms in today's day and age, right? Labor market's tight, difficult to find people. So you're relying on outside entities to help you, staff your organization. And so what I thought I would do is go over some of the things you should be thinking about when you're engaging in a contract with a temporary employee staffing firm. And perhaps it's time to take out those contracts that you might have with those vendors and see if you're getting the most protection that you need. And I will note that we might have some staffing firms on this webinar right now because we represent them as well. And this is all sort of relevant to both sides of the coin in some ways. So if you could next slide, Kathy. And I will say, if you have an arrangement with a professional employer organization, a PEO that basically puts your employees on their payroll, slightly different considerations. I'm really focusing on temp arrangements right now. Some of the concepts do overlap, though. I will say, as a starting point, the biggest risk that we see when you are engaging, with temporary employees is that there may be a finding of joint employment. So that if there's something that the agency does that is unlawful, you might also be on the hook. And as much as we try to draft these agreements to minimize the risk of joint employment finding, it's really, really difficult to do so, because the fact of the matter is, if you have an individual assigned to work at your facility and they're working under your rules, under your local supervisors, you can basically be assured that there'll be a joint employment finding. We could do a whole other presentation about what those factors are and how to minimize that. But just know that when you're entering into these arrangements, you should sort of assume that you will be found to be a joint employer, and then try to do the best you can contractually to minimize the risk of what might flow from that. So, one thing you'll want to address in your contract is how you're allocating the duties and responsibilities between the agency and the receiving employee. That I'll call that the client, right? So I'll call it the agency who's supplying the employees and the client who's receiving the employees. You'll want to make sure that the agency is properly checking the employment authorization of an employee to make sure that you're not getting into trouble in terms of immigration, things like that. You'll want to specify who's performing the screening, what type of screening is being performed. Are you expecting a background check? If so, you'll want to specify that in the contract. Who's doing the training? And this is where it kind of gets more complicated in terms of, it might be different for different kinds of workplaces. But, if it's routine work that can be trained by the agency, it's probably better to reduce joint employment finding. But realistically, if the work is specific to your workplace, it's going to be the client organization providing the training, but you want to specify who's responsible for the training. You'll also want to specify who's responsible for supervision. And what about hiring and firing and discipline? What about those things? Who's allowed to do that? Are you as the client allowed to do that? Or should that be left to the agency? Because again, the joint employment issue. Safety is, the OSHA will find that both organizations are responsible for providing a safe workplace. So you'll want to have terms built into your contract that address the responsibility of providing a safe workplace. And in terms of health benefits, you want to keep in mind that under the Affordable Care Act, a client may still be expected to provide health insurance for that person, unless you deal with that issue in your contract. So you want to make sure there's something in your temp agency staffing agreement that addresses the Affordable Care Act and who is responsible for the employer mandate. I think that's actually a very important term that I don't see a lot, but that I would recommend adding. The next bullet here that I mentioned is duration limits. So temporary employees by their term is a short-term thing, and sometimes you don't actually see clients putting time limits on it, but I can think of a few scenarios where that would be a good idea, such as when a temp employee needs to take a leave, a Family Medical Leave Act, situation, and then they want to come back to the job and say, well, it was a temp assignment, and if you don't have that documented somewhere, that can be more difficult. I'm not sure that will always work in your contract because it might be different per assignment, but figure out a way where you're documenting that. Next slide, Kathy. and I know I just have a few more minutes here. You want to make sure that you very clearly set forth that the parties are acknowledging that they're complying with important laws. So particularly EEO laws, leave laws, immigration laws. You really want to specify in the contract with the staffing agency that both sides are complying with those laws. I recommend for clients that if you can, I would seek to have a provision that allows you to inspect the records of the temp agency to really confirm that they are following those laws. Do they have the right policies in place? Are they doing the right things? Because you're really handing over a whole lot of responsibility to them in the process leading up to the assignment. You want to address insurance coverage likely. Does the temp agency have the right kind of insurance to cover any problems that might occur? And you might want to think about whether do they have employment practices liability insurance in case there is a discrimination claim that you're both on the hook for. Do you want to require them to have insurance to deal with that? The big provision that is negotiated most is the indemnification provision. And indemnification is this concept of shifting liability. So if someone comes along and says, a former temp employee and says that I was discriminated against, and they bring that suit, and you as against say both entities, or even just one, say they bring it against you as the client, and you say, well, wait a minute, this was a temp employee, and they're making allegations about how they were paid. Well, you as the receiving client organization had nothing to do with how they were paid. So you would want to have a very strong provision in your contract that's indemnifying you for any suits from third parties related to that employment relationship. And if you're accepting a template from a temp agency and just signing that, likely they're not giving they're not going to provide a provision for indemnification that's very helpful to you. So that's why you really want to look at that and negotiate that. By the same token, whichever party is introducing the first draft of the contract is probably trying to limit their liability. And so you want to make sure you're looking at that to make sure it's not done in an uneven or unfair way. So take a look for that kind of section in your agreement. Next slide, Kathy. You want to address the billing terms of the arrangement, who's signing off on timesheets and what does that mean? Is there a warranty? Meaning if they send an employee over and they're not a fit at all, within a certain amount of time, are you off the hook for paying for that person? That can be contracted for and is a good idea. You want to make sure you have clear language that if the person is working overtime, that they're getting paid appropriately. And that the agency who is responsible for payroll is aware of those obligations and committing to follow through on those obligations. Another interesting concept is, what about legally mandated paid leave? So in today's day and age, we have New York sick leave that's mandated. And so what if a temp employee has a sick day? Who's responsible for paying for that? Is that the cost of doing business for a temp agency, or is that a cost that gets passed along? I've seen it contracts where the agency does try to pass that along, and it's a question of whether that's what you're expecting and bargaining for in this relationship. A couple more things: conversion fees. If you end up hiring someone who has been a temp after a certain amount of time, at what point, can you just do that without penalty, or will you have to pay some sort of fee to convert that person to a full-time employee? You'll want to take a look at that provision and see how it's structured. If you have temp employees who are going to be dealing with confidential information, how are you dealing with that? Are you making sure that your contract specifies that those employees, those temps, are signing confidentiality agreements? That's something you should consider. And intellectual property, this might not apply to every single type of temp employee you have, but if they're doing work that could create intellectual property, you'll want to address who is the owner of that IP. So lots of things to think about in these agreements. Kathy, do I have another slide? I don't remember. No, I don't. Okay, so those are the things that you'll want to consider. I know I just flew through that, but consider that, take that list, pull out your old agreement, that you're working under right now. Is it sufficiently protecting you? Are you in a position where you can renegotiate that? Just some fall cleaning to think about. It's not spring, but maybe it's a fall project for you. So anyway, we'll end things there. I know I went over by a minute, and sorry about that. But if you have any questions for any of us, here are our email addresses. We've tried to answer any questions you put in the Q&A, but thank you for joining us, and we'll see you again on a future Tuesday. Bye-bye.